hearing for the Fife Council Beech Way, Dalgety Bay Compulsory Purchase Order 2022 made by Fife Council. Now and throughout the meeting, if you could please mute your microphones when not speaking, but keep your videos on. My colleague Ewan Murray, who you met when you came into the meeting, he's going to stay online with us in case we come in under any technical issues. Speaking of which, I'm on a remote microphone here in the DPA office, so if you could just wave just to confirm you can definitely hear me, that would be great. Yeah, you can. Thanks very much. My name's Tammy Swift-Adams, and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Department, DPEA for short. A public inquiry is to be held into this order because there's been an objection made to it, and that objection has not been withdrawn. I've been appointed by the Scottish ministers to consider the order and the objection, and my role is to hold the inquiry and prepare a report for ministers that sets out findings of fact and my recommendations as to whether or not the order ought to be confirmed. A few housekeeping matters before we get into the main business. The meeting's being broadcast live and it's also being recorded, so by participating today, you're consenting to being filmed and to the recording being used for training purposes and as an archive record, with that record being made available to members of the public through the DPA website. If you need to attract my attention throughout the meeting, please just wave your hands and I will try and keep an eye out for that. Please also switch off your mobile phones or anything else that might make a noise. And sorry, it's more likely to be me with my fire alarm, I know. Here at the DPEA office, we're still adhering to applicable COVID-19 guidance. It's up to you to do likewise where you are. I've crossed out, there's no planned fire alarm. An agenda was circulated a week ago, so you should all have that. Try and progress through that as quickly as we can, pausing for discussion where necessary. I haven't planned in a break, but if we get to an hour or so in and find we've still got quite a lot to discuss, we can review that at that point. But just let me know if you do find you need a break at any point in the meantime. Okay, so I'll move on to agenda item 2, which is just a few more points from me. The order is proposed to be made under the Town and Country Planning Scotland Act 1997, also the Acquisition of Land Authorisation Procedures Scotland Act 1947, Compulsory Purchase by Public Authorities, Inquiries Procedures Scotland Rules apply. Circular 17 1998 explains how those rules work with a plain English guide at Annex A, and I will provide links to those documents in my note of today's meeting. The purpose of today's meeting is to discuss the procedural arrangements for undertaking the inquiry. Please remember that today's meeting is not an inquiry session itself, and we won't be discussing matters related to the merits of the order or the details of the papers that have come in so far. I should also confirm that compensation issues are beyond the scope of the inquiry and of my role. I'm hoping today we can agree broadly a plan of action and a suitable timeline for the inquiry, and the agenda that I've circulated includes a provisional timetable that we can discuss shortly and adjust if need be. So unless parties have any questions at this point, I'll move on to introductions from yourselves. Okay. So if the lead representative for each party could please introduce yourselves and the members of your team and tell me each person's role in the process, that would be great. And I'll start with Fife Council, acquiring authority.
Thank you, ma'am. Just checking if you could hear me okay. My name is Chris Devlin. I'm a director with the law firm Anderson Strathern. I'm acting on behalf of Fife Council today. On my left is Sheila Roger. She is my instructing solicitor at Fife Council. On my right is Ronnie Hare. He's the Property Investment and Development Manager in Economic Development, Business and Employability Services at Fife Council. And immediately next to Ronnie is Anne Rennie, Lead Professional with the Economy, Planning and Employability Services Department within Fife Council. These are the individuals at Fife Council who are primarily responsible for promoting the order. In the council's outline statement, we did refer to 3 potential witnesses. Those witnesses are not with us today for the purposes of this procedural meeting, but I'll just mention those again for completeness. Those are Mary Stewart, who is the Service Manager in Planning and Policy for Fife Council, who would speak to planning matters. Andrew Riley of Andrew Riley Associates, who would speak to economic and employment land matters, if appropriate. And Chris McMenemy of Fife Council, and he's basically responsible for employment land audits within the council. As I say, those witnesses are not with us today, but in the event of an inquiry or a hearing session being held in respect of any of those matters, then we would be calling upon those individuals.
Okay, thank you. And I think they were listed in the outline statement of case that you sent in, so this is the same names. Okay, and statutory objector.
Thank you, Madam. Neil Collar. I'm a solicitor, legal associate of the Royal Town Planning Institute, and a partner at Brodie's LLP. As you said, I'm representing the objector, United UK Propco 2 Limited. From the company, Graham Stewart was maybe going to be attending. I don't see him, as it were, on the screen.
No, I don't.
It might be that he might join us later, but he wasn't intending to speak. So he would just be a listening presence only.
Okay, he might be on. He might be watching online, so I think I'll have had the link to just watch online as well. Okay, and in terms of any witnesses forward process, you didn't name anybody, but you'd said somebody can be confirmed from mile away. Would that be Graham? Possibly.
Possibly. I haven't actually directly asked him that question.
Okay, that's fine. I've got it down as named to be confirmed witness from mile away, so it's fine. And similarly, you'd mentioned potential architecture and planning witnesses depending on acquiring authority evidence. So is that be confirmed still? Also,
it is at this stage. I think it is unlikely, and I appreciate one of the main purposes of today is to talk about timelines. So in my experience, when we're talking about timelines, it tends to be useful to be a little bit pessimistic to make sure we don't run out of time. But certainly, if we were calling either or both of those witnesses, I wouldn't anticipate them taking a significant length of time.
okay. Okay, so we'll watch out for Graham Ewan in case he does arrive. We'll carry on in the meantime. So I'll move on to item 4, which is the issues that will need to be addressed and require further procedure. Just to be clear, the section is not intended as an opportunity to sort of rehearse the evidence at all, look at the merits. It's just to give some context for agenda item 5, where we look at the procedures for taking evidence. Based on the documents so far, I've provisionally identified 2 broad areas of dispute. One is the requirement for the scheme, and the second is the development plan and wider policy justification for the scheme. Just let you note those down. So I realise those headings, particularly the first one on the requirement, they're probably going to encompass quite a lot more granular points that are in the submissions that you've sent in. So I'm quite keen to hear your views on whether you think those headings capture within them the main issues of dispute, or whether you think there might be benefit in breaking them down a bit or adding some more. And can I start with acquiring authority, please, Mr. Devlin?
Thank you, ma'am. In terms of the 2 matters that you've identified, I think that taking them as very broad topic headings they probably do cover everything that Fife Council considered would be necessary to be discussed as part of any investigation in terms of the CPO. In particular, I suspect that submissions of some description would be required in terms of the newly adopted National Planning Framework 4, which is not some form part of the original CPO as it was being promoted. That is a specific point that I suspect would be mentioned. But with the exception of that, I don't think I would have anything further to add to the comments that you've just made.
Okay, thank you. Mr. Collar?
Likewise, my feeling is that those two headings are sufficiently broad enough to capture, as you say, the granular detail. So I don't think it's probably worth discussing it in any more detail. I suspect we could discuss it round and round, but probably actually still agree that, broadly speaking, those cover it. So I'm content.
Okay, that's good. Yeah, I did start thinking about possible subcategories, but they all sort of link back, particularly most of them link back to the requirement, just by way of example. I was thinking about the various legislative provisions, but again, they're there to demonstrate an order's required or not, so they're covered in that. Okay, that's fine. Something else I was going to cover under this point is the opportunity for a statement of agreed matters. I haven't included one in the timeline that I set out, but I just wanted to ask whether parties think that one of those would be helpful or necessary in this case. Mr. Devlin?
Thank you, ma'am. Insofar as the council is concerned, I would certainly be willing to work with Mr. Collar and the statutory objector to produce one if it was felt that it would be helpful. Having said that, having had a look at the various submissions that have been made, we do wonder if such a statement is likely to be quite sort of matter of fact, if I can put it that way, in terms of simply, this is the relevant legislation and so forth. I think the matters of dispute are probably pretty well established, and the matters that are agreed are probably pretty well established from the submissions that have been made. But certainly, if you, ma'am, considered that it would be helpful, and also if Mr. Collar considered that it would be helpful, then we would be happy to work together to produce one.
Thank you. Mr. Collar, do you think it would be helpful?
I agree with Mr. Devlin. I must admit, from experience, I'm rather sceptical about the exercise of producing a statement of agreed matters. Certainly, once it gets down to useful detail, as it were, unfortunately, lawyers being lawyers, we can end up spending as much time arguing about the words we're using and not making much progress as a result. So, as Mr. Devlin said, I think the danger is that a statement would be a statement of the obvious almost, and not particularly useful as a result. So I agree with him, and if you excuse me putting the ball back in your court, madam, that if there's anything that you feel would be useful, then certainly willing to address that. But as Mr. Devlin said, I think it's actually reasonably obvious what is agreed or not disputed, and probably not particularly productive to try and bring that out in a statement. As I say, well, as Mr. Devlin said, the danger is either it's fairly anodyne or as I was mentioning, if we try and take it on to more useful detail, it can get bogged down.
Okay, well, I'll leave one off the timeline for now. As I said, I didn't put it on originally, and I'll only add that in afterwards if I decide this. I think it would be particularly useful, but from the sounds of things and from the documents so far, I think you're both probably right, but it might not add a lot other than taking some time up. Okay, I'll move on to item 5 then, and the process for hearing evidence. So you'll have seen that I put a provisional timeline in the annex to today's agenda. And we'll discuss the dates and the times themselves under the next item. But the table also shows what an inquiry process could look like if it includes a hearing or inquiry session or sessions. But that sequence of events and choice of events isn't set in stone yet. And I'm quite keen to hear parties' views on what you think the most appropriate procedures for hearing or taking evidence on the disputed matters would be. There's a little bit in your outline statements of case. So I'm going to start with the acquiring authority. And Mr. Devlin, I think you've already indicated on the council's behalf that you think all the matters in dispute could be dealt with in writing. You don't think there's a need for a hearing or an inquiry procedure. So can I ask you, does that remain your view, and is there anything you'd like to say around that point?
Thank you, ma'am. Yes, having discussed with the council, we consider that further written submissions would be sufficient to provide the level of evidence that we think would be appropriate to determine the matter. The outline statements of case have been provided, but of course more detailed statements of case would be likely to follow. And those statements of case, including further written submissions on specified matters, we think would be sufficient to provide you with the evidence that you need. In particular, for example, it was referred to earlier, a submission on the Fourth National Planning Framework. We think that a written submission in respect of a matter along those lines would identify the relevant issues for you and provide you with the council's view on that, as well as, of course, an opportunity for the statutory objector to do the same. So it remains the council's position that written submissions would be appropriate in this matter.
Okay, and do you think that same further written submission could encompass that wider development plan and policy justification point with NPF4 within that?
Yes, we do. Clearly, as Faith Council, we would be looking at the development plan, including the newly adopted NPF4, and looking at the relevant policies to provide an appraisal and an assessment of the council's proposals in respect of the CPO land against that updated development plan. We consider that a written submission could do that sufficiently as an assessment against the development plan for you.
Okay. And that point on policy, that's also intended to encompass the wider, non-planning policies and strategies. I think there are some of those listed in both parties' outline statements of case. So just a reminder that that's not purely development plan; it's the wider policy and strategy too. Okay, and Mr. Collar, I think for the statutory objector, you've referred to witnesses that you might call. I don't think you specifically said you wanted an inquiry or a hearing, but you did allude to witnesses in that event. Have you got a view on appropriate process?
Thank you, Madam. And apologies for not confirming the position earlier. Inevitably, because compulsory purchase is unusual, it's required a bit more discussion with the client, in contrast perhaps to a planning permission appeal, where we're all much more used to how the procedure works and what's going to be the best procedure. The legal position as I understand it, is that as a statutory objector, my clients have an absolute right to have an inquiry and don't require to show any cause. My instructions are that they do want that inquiry procedure, but that was my recommendation to them, given the circumstances of this CPO and the nature of the disputed issues. My view from experience of both, well, not both, the various options, inquiry, hearing, written submissions, was that to properly focus on some of the nuances in the evidence that's come out so far, it would be necessary to have cross-examination of witnesses. So, as I say, my instructions are that the statutory objector does indeed request a public inquiry. After saying that, on the specific issue of MPF 4, clearly there's scope for some written procedure on that in advance of the inquiry, but I appreciate that's a slightly separate issue, as it were, and we can maybe return to have a discussion about the mechanics of that in a minute.
Yeah. So in an inquiry session, would the statutory objector be looking to cover all of those, the entirety of those 2 points that we've agreed are the main disputed matters? Or would it, for example, be more focused on the issue of whether the order is required rather than the policy and strategy?
The same thought had occurred to me, for instance, whether it was necessary to have a planning policy witness from the council. At this stage, my view is that it is necessary, but as you've just said, the main thrust of the statutory objector's case would be the requirement for the scheme, and I don't think the second theme that you'd identified about the development plan and wider policy justification, I don't think that second theme would require much inquiry time. The main focus would be on the requirement for the scheme.
Okay. So I'll just bring the council back in briefly with their observations on that. So what we're looking at in terms of what the statutory objector is suggesting is an inquiry session principally focused on the requirement for the order, but with time scheduled into it as well for cross-examination of planning policy witnesses, but potentially with the scope of that part of the inquiry reduced through a further written submission on policy beforehand. Is that something you can work with? Mr. Devlin?
Sorry, ma'am, I was just finding the microphone button.
Sorry, I thought you'd frozen for a second. So,
in terms of the evidence that's necessary, ultimately, of course, it's for you to decide how you want to conduct matters. Certainly, it would be the council's preference that, as far as practicably possible, anything that can be dealt with by means of written submission should be dealt with by means of written submission. We have, of course, offered up witnesses in the event that you do decide that inquiry sessions are necessary. In terms of the evidence to be provided, I do take the point that Mr. Collar has made about an absolute right to an inquiry session, but whether or not it would be possible instead to have a hearing session where perhaps the evidence could be more fruitfully discussed. In terms of the matters at hand, it strikes the council that cross-examination of witnesses is generally reserved for complex technical sort of evidence, And the council did not consider that there was that sort of evidence necessarily being led here, as there would be, for example, if it was a noise session with a wind farm inquiry, as an example. So whether or not it would be possible to hold a hearing session and substitute and have a structured discussion, if the statutory objector would be content with that, then I think that would be the preferred fallback position. But ultimately, just to confirm, we have provided a list of witnesses for the purposes of any procedure that you ultimately decide is necessary, and we'll simply take your lead on that for the evidence that you think you require to deal with this matter.
Okay, thank you. And Mr. Collar, presumably, if you discussed the option or the differences between the hearing and the inquiry with your client, and they've settled on inquiry.
Correct, madam. I did spend some time thinking about whether a hearing would be suitable. I do have experience of hearings that have been incredibly constructive and useful. But as I said, the advice and the recommendation I gave to my client and they accepted was that because of the nature of this case, it being a compulsory purchase situation where, as we mentioned, we're focusing on the requirement for the scheme. My advice was that my ability to ask direct questions of the council witnesses was very important. And as you're aware, at a hearing, there isn't that opportunity for cross-examination. You would be the person asking the questions. Hence, the recommendation to my client that we go with inquiry procedure. And just to reassure parties, madam, I don't think I've been involved in appeared in an inquiry you've been involved at. I can't remember with Mr. Devlin, but my cross-examination is always very focused and efficient, and will not spend time on very, very broad background matters.
My initial thinking was that for my purposes, I would find either a hearing or an inquiry session helpful in this case. So if the statutory objector does want an inquiry, then we should program that in. But as you say, try and make sure it's focused and efficient. We can perhaps do some further work between now and then to look at structuring that if that's possible. In terms of the duration of an inquiry, how much time do parties think would be required for that? I'll start with you, Mr. Collar.
Thank you, madam. I was expecting Mr. Devlin, if he was asked first, would say Mr. Collar's probably going to be the person who takes the time, because I will have 3 witnesses to cross-examine, and it's the cross-examination that takes the time. I'm optimistic that 2 days should be sufficient for the whole inquiry. In my experience, 2 witnesses a day it is definitely achievable. It's quite possible we might even be able to rattle through it in a day. One point of detail I appreciate, it's probably more for later in the timetable. Oh yes, in fact, it's under item 5. Madam, you're proposing that it be held virtually. I've no objection to that. Obviously, wait to hear from the council. I am aware that certainly hearings that have been done virtually don't sit for as much of the day as we would do if we were in person. Longer breaks, I think, are programmed in. But I still think even if we had longer breaks to address that, 2 days should be sufficient. I'm also assuming within that we could agree that closing submissions could be done in writing and exchanged electronically, as tends to be the practice with planning inquiries.
Yeah, that would be what I'd propose.
Yeah, and in contrast to planning inquiries, there won't be a need to discuss conditions or anything like that. So it is just the cross-examination of the witnesses that we're really looking to programme.
Okay, and in terms of... Sorry,
what I was going to say was it might be possible, we don't necessarily need to do it now, but to agree that witness precognitions could be taken as read, or just very brief summaries could be read out. I appreciate that's something that Mr. Devlin would maybe want to discuss with his witnesses. I know some witnesses feel it's quite good to have a chance to read out something to feel comfortable rather than jumping straight into cross-examination. So I don't have a strong view on that. I'm just also aware sometimes time can be taken up with something being read when all the parties have actually had a chance to read it themselves, and it's not necessarily productive.
Okay. And in terms of how the time, so if that was 2 days was used, how much of that would you envisage being taken up by the requirement for the order as opposed to the policy and strategy?
I'm thinking of the best way of answering that. Probably the best way of answering that is Mr. Devlin has mentioned that the planning policy witness would be Mary Stewart. The other two witnesses wouldn't appear to be dealing with policy matters. I feel at this stage cross-examination on policy, planning policy, other policy matters probably wouldn't be more than about 30 minutes, 3/4 of an hour. Okay. So I don't know if that is a helpful answer to your question. It's not really saying how long I would need on the requirement side.
No, it's just to start envisioning it ahead of time, but that doesn't have to be in stone. And I guess that would be partly dependent on how some of the documents, where some of the documents mentioned in the outline statements of case fit. So there's various strategies, for example, whether they end up fitting in with policy or the requirement justifications. So maybe not easy to give a firm answer on that. Yeah. Okay, Mr. Devlin, do you want to come in? Have you got any comments on what Mr. Collins has said or suggested?
Thank you, ma'am. In terms of timescales, obviously we'll have to take a bit of a lead from how long Mr. Collar might consider he would require to cross-examine any witnesses. But certainly, 2 days of inquiry, if that's the way that you wish to obtain your evidence, wouldn't necessarily seem to us to be an inordinate amount of time. That seems like a sensible amount of time.
Okay. And there's enough time for you within that, based on the information Mr. Collins provided about witnesses?
I think insofar as witnesses are concerned that Mr. Collar might bring, on the basis that he would be proposing only one witness potentially, I think that probably does provide sufficient time but perhaps that's something that can be bottomed out with further exchange of correspondence with Mr. Collar and the Directorate in due course, once he knows exactly what's going to happen insofar as his own client is concerned.
Okay, so if more than one witness, possibly 2 days might be more of a squeeze. So I'll just bear that.
Potentially, I think, yes.
Yeah, I'll bear that in mind then. Okay. So we've dealt with duration, we've dealt with virtual or in person. So in terms of the timeline, that's under the next agenda item 6. So I think the components are broadly as I have included here, in terms of there isn't a statement of common ground to add. There is an inquiry session. We now know that's going to be 2 days. We had an exchange already about the possible time and date for the inquiry session, and that was tricky. I think I'd originally suggested the 10th, which I think didn't work, Mr. Collar, for your client. The week before and after that didn't work, Mr. Devlin, I think, for the council. Is that right? Is that full weeks, or are there days in any of those weeks that are available?
In terms of the availability of council witnesses, the complicating factor, which I think is something that Mr. Collar has referred to actually as well, is the Easter holidays and the timing of the Easter holidays. So in terms of availability of witnesses, the council, I think, would suggest it would be safest to proceed that the week beginning the 24th of April would be appropriate, because that would be a point where we can effectively guarantee availability of witnesses.
Okay, and was that week okay for the objector too, Mr. Collar?
Yes, madam, with the exception of Friday the 28th. So the Monday, Tuesday, Wednesday, Thursday are all fine.
Okay.
And just picking up very quickly on the end of what Mr. Devlin said a few minutes ago, it might be prudent to programme 3 days on the basis that we're then all available, and if we get it done in 2 days, then that's a bonus.
Okay. So that week is okay for our IT support, given it's virtual. I know they've got an in-person session on the Wednesday, but they've said they could still support a virtual session on that day. So in terms of the days available, it would be to suit us. Could I suggest that we go for the Tuesday and the Wednesday, with Thursday as the backup day? Pretty happy with that? So I'll confirm that. So that's 25th, 26th, 27th of April set aside for the inquiry. In terms of the lead up time to that, I had allowed, shall I just reprofile that timeline with the same gaps of time in between the different submissions? I think, let me have a look at that. I think I've allowed 4 weeks before the submission of statements of case and case documents, and 2 weeks for precognitions and summaries. Is that okay with you, Mr. Devlin?
Yes, I think that should be fine for the council. Thank you, ma'am.
Yeah, and Mr. Collar?
Yes, ma'am. And just reminding you that if we could pick up separately on MPF 4.
Yeah. Yeah, I will look at, I'll have to build that into the timeline. People want to make any suggestions while we're online together for how we might fit that, where that might best fit in?
I was wondering, madam, if mechanically, maybe the best way of dealing with this is if you issued a procedure notice requesting written submissions from both parties, and perhaps seeking a view from the council initially, given that they have a planning witness who could prepare that, and it might be more efficient if they prepared a submission and then the statutory objector had an opportunity to comment on that, rather than us both preparing submissions and then having to comment on each other's. And I'm not anticipating that the NPF4 provisions will be particularly controversial or actually introduce any significant changes. I think it's probably a bit of nuancing again, but clearly until we've all had a chance to actually sit down and figure out how it applies to the CPO, it's a bit of a wait and see.
Okay. So, Mr. Devlin, on behalf of the council, are you happy with that proposal then? Further written submissions, specifically bringing thoughts on NPF4 into the mix from the council with the statutory objector to comment. Are you happy with that in principle? And also, I mean, that's perhaps something that could just get underway fairly soon. Would that be all right with you?
Yes, ma'am. I think in principle that sounds absolutely fine, and I tend to agree with Mr. Collar's view that it's unlikely to bring anything sort of new to the table, aside from the fact that it now forms part of the development plan, and it's probably just a little bit of nuance. So yeah, that sounds fine too.
It would just update the picture to include that new development. Okay, and I think there's plenty of time for that to fit in before we get to the updated dates for submission of statements of case.
Madam, just for clarity, I wouldn't like the position to be misunderstood. Although I'm suggesting the written submission, what I have in mind is that would then be open to cross-examination at the inquiry in terms of the overall contextualising. So the intention wouldn't be necessarily to go back over what had been discussed in the written submission, but there may be some wider context which would be appropriate to cover in cross-examination.
Okay. I'll make a note of that. Have you got any comments on that, Mr. Devlin?
No, NPF4 clearly forms part of the development plan and part of the conversation that we've had about the nature of the witnesses and so forth. We'd open that up.
Yeah, so that'd be covered anyway. Okay. Thank you very much. Is there anything else that you think it would be wise to build into the timetable? I've got submission of case documents down there. I noted there are some documents mentioned in both parties' outline statements of case that aren't with me yet. Is the submission of documents likely to go beyond the documents that each of you has already listed? Mr. Collar, I'll start with you.
I wouldn't expect anything additional that is significant. If there was anything additional, possibly some things more in visualization, illustration, but very much background. But one thing that I do vaguely have in mind is the council's, I think it was their outline statement, referred to a new report, which I don't think my clients have seen yet. I appreciate it is new, a bit hot off the press. So once we see that, it might be that we might want to lodge something in response. And at this stage, I'm not anticipating anything significant.
Was that the 2022 audit, or is that something else?
I think it was something else. Apologies for being somewhat vague. I think there was a document that was informing perhaps the next audit. If you bear with me, I might be able to just bring it up and then remind myself. Yes, madam. The one I had in mind is the Industrial Land Review Report, which actually I see has a document number. I'm not sure, though, that I've actually got a copy of that document, but I assume if it will be on the DP website.
I don't think that one is yet. And this is the point I just briefly mentioned earlier. I think there are a few documents, both in the statutory objector and in the acquiring authorities lists of documents that haven't been submitted to us yet, and that might not be in our core document library. So I will double check on that, and I'll perhaps confirm in the note of this meeting of the documents that you've both listed, which ones are already with us, which are in the core library, and which ones aren't. Because it might be, I think they all sound like they're documents, apart from any update to the land audit, they all sound like documents that would be readily available that you could probably submit quite quickly. So I'll just clarify which ones we do already have in the note of the meeting. And Mr. Devlin, on behalf of the authority, are you also proposing just to rely on the documents that you've already listed, or is there anything else that you're envisaging being relevant?
The council would propose to rely on the documents already listed. If there is an update available in terms of the employment land, then it may be that we would seek to lodge that as a document in due course. But that will only come forward if it is ready and in a position where we can do so. And the relevant department in the council is still working on that.
Okay, yeah, and I noted the audit was mentioned, but it doesn't have a document number in your sequence. Okay. I think that might be everything on item 6 in terms of the timeline. Is there any further comments either party wants to make in terms of the timeline and the main items, main milestones along the way?
Comments from the council, ma'am?
Okay, so I'll put a reprofiled timeline into the note of the meeting with those dates that we've confirmed for an inquiry session, and then working back sequentially from that and starting with that further written submission that we've mentioned. Okay, moving on to item 7, site visit by the reporter. I think in the agenda I noted that I was proposing to undertake an unaccompanied site visit. I just wanted to check whether parties were content with that. I'm quite keen to know, is the site sufficiently visible from the surrounding roads? And if I did need to get into the site itself, is that possible without assistance? Mr. Collar, I'll start with you.
I would need to check with my clients, ma'am. I haven't actually been to the site yet.
No. Okay. Mr. Devlin, do you and your colleagues know?
If you give me one moment, ma'am, I'll just ask my colleagues.
Yeah, they might know.
My client tells me that the council can that the site can certainly be seen from the roadside, but that it would otherwise be a secure site. So I suspect that you would need to liaise with Mr. Collerman in terms of gaining access. On your proposal for an unaccompanied site visit, the council has no objection to that.
Okay. What I was thinking was I can probably see, as long as I can, see into the site, that is probably enough in terms of the site itself. If it's just, it's described as a cleared site, there's nothing on it of detail that it sounds like I specifically need to see. It's more just, familiarising myself with the site in the context of the surrounding area and surrounding uses, particularly some of the sites and other units that have been mentioned in both parties' submissions. So I'll stick with that as my plan of action. But Mr. Collar, if you come back to me with any comments from your client on that, if he doesn't think that unaccompanied site visit's going to suffice, then you just let me know as soon as possible. Okay. Okay, I'll move on to item 8. In terms of document handling, there isn't a huge number of documents for this inquiry at this stage. So I'll look at that final list and see whether or not we need to put together a formal core documents list. And as I said, I'll have a look at what we've already got in the library and what's already been submitted and the additional documents that we just need to come in. For some recent inquiries, GPA had a procedure where we uploaded all of the documents onto USB sticks and distributed them to participants before inquiries, but I think we've stopped doing that. It didn't prove to be very, very time efficient, and there were some issues with postal delays and data protection. So where there is document handling required now, we use Objective to Connect, and parties can then download or look at all of the documents that we need for the inquiry on there. So I think that's how we would work for this inquiry. Parties happy with that?
Sounds reasonable, madam. I think, as you say, given the relatively small number of documents, we can probably all work out our own ways of dealing with it, as it were.
Yeah. That'll be on the website or in the core documents library in plenty of time. Okay, moving on to correspondence. The case officer, you'll already have dealt with her several times, as Laura Walker. She's the main point of contact throughout the process, so she'll liaise with you and liaise with me as need be. And she'll help make sure all the relevant documents are uploaded and circulated and people know where they can find them. And then finally, the note of the meeting, I'll issue that to all parties and put it up on the DPA website next week, hoping to do that within a working week. And that will have all of the updates, information that I've mentioned today in it. Okay, so moving on to item 9, which is really just a chance for either party to raise any other relevant matters that I think it'd be helpful for us to discuss today. I'm going to start with Mr. Devlin for the acquiring authority.
Thank you, ma'am. We don't have any further matters to raise at this time.
Thank you. And Mr. Collar?
Nothing from me either, thanks.
Okay. Well, thank you all very much for the time participating today, although it's not been a huge amount of time. I'll go through that very quickly. It's helpful to have the clarity on the process and timeline, so I'll send that out confirmed as we've discussed today. So I'll just say goodnight for now and look forward to seeing you in the inquiry session in due course. Thank you very much. I'll close the meeting. Bye.
Thanks.
Thank you, ma'am.